Welcome everybody. This is quite a large audience as we understand it to be. Today, I, Lachlan Wilson, and a colleague, Daniel Brown, from 3PB Barristers, are going to be taking you through the redundancy process, particularly with regard to where we are now in 2020, and I hope giving you something of a slightly different slant to the process that will help advise and inform you. Some housekeeping points to begin with. We will be distributing materials. They will actually be these slides. They will be distributed to everybody who's provided their contact details, who has registered. They will be sent out. So do not worry if during the course of the webinar the dog barks at the postman and you miss a slide. You will always have the opportunity to see them at a later stage. The second point of housekeeping is questions. Some of you may very well have questions. Please do use the Q&A button at the bottom of the screen, and during the course of the webinar we will, each of us who are presenting this in turn, will take the opportunity when we're not presenting to have a look at the questions, and hopefully at the end of the webinar we'll be able to provide as many answers as possible. So without further ado, one other person I haven't mentioned, but I will mention, is a person called Liz. You will not see Liz, but Liz is the person who I'll be asking, and both Dan and I will be asking, to change the slides for us. So when I say, next slide please Liz, please don't think I've somehow personalised my computer. Over to you Liz, for the first slide. Okay, so we're redundancy in 2020, and I just want to have a look, next slide please Liz, at what we're going to be discussing today. Here's our agenda. I will be taking you through the definition of redundancy and why we're here. Dan will be taking you through pooling. I will then come back to deal with consultation. Dan will deal with selection. I shall then deal with alternative employment, and Dan will conclude with procedure, and then hopefully, as I say, we'll have time for some questions afterwards. So the next slide please Liz, is where we kick off, the definition of redundancy. Why are we here? Well, the question, and I apologise for the existentialist nature of it at this time on a Thursday morning, but I have deliberately set up this first slide in this way. I've set out the two contenders in the issue, either those responsible for the direction and management of a business seeking to make cost savings in a way that envisages letting go of staff, or the employee who's actually at risk of that. Looking at the delegate list as I have, it's quite clear that you could be neither of those, but you're probably somebody advising people in that position, whether from a human resources perspective or from a legal perspective. But the starting point I have deliberately pitched as this: both sides are coming from the same starting point, and that is the requirement to have a fair, reasonable and correct decision undertaken, whether they're the subject of it or whether they are actually the decision maker. Next slide, please. So we begin not actually with the statutory definition of redundancy. We begin with the starting point for fairness. Many of you may be familiar, that's section 98 of the Employment Rights Act, 1996. And in determining whether a dismissal is fair, we must show as an employer that it's for a fair reason, and it is some other substantial reason of a kind as to justify the dismissal. And of course, a fair reason under subsection 2 of section 98 is that the employee was redundant. So fairness is our starting point, but it doesn't end in sections 98(1) and 2. Next slide, please. Fairness goes on in section 98(4). The determination of whether the dismissal is fair depends on whether in the circumstances, and that takes into account the size and administrative resources of the employer's undertaking, whether the employer acted reasonably or unreasonably in treating it as a sufficient reason for dismissing, and it shall be determined in accordance with equity, and the substantial merits of the case. No process can ignore the amount of fairness that is embedded in the legislation. And here we are, the statutory definition of redundancy. This is the reason that must be shown to establish fairness if you're not going to rely on some other substantial reason justifying dismissal. This reason requires that the dismissal is wholly or mainly attributable to the fact that the employer has ceased or intends to cease carrying on business for the purpose of which the employer is employed, or carry on business in a particular place where the employer was so employed. Or that the requirements of the business, and this is now looking more at the diminution of the requirements of the business, for employees to carry out work of a particular kind, or for employees to carry out work of a particular kind in the place where the employer was employed, is expected to cease or diminish, or has ceased or diminished. So it's a diminution in either the work available for the employer, or the work available in the specific location for the employee. So that's our definition of redundancy. And where do we see it in terms of dispute? And I deliberately conclude this section on this slide, because when we have a challenge, normally the challenge is the decision is not genuine. This isn't a genuinely redundancy situation. And in fact, what is happening is that there is some pretext or sham, and they have selected me for some kind of personal issue. Now, that's where in 2020 we are in a different place. We are not in the mid-1980s where there was boom in most industries and redundancy was used as an ability of companies to somehow see that they could get rid of dead wood. We're not there in 2020. Businesses have been unprecedentedly assailed by a coronavirus. So it is more likely that you would be able to establish the redundancy situation as opposed to the allegation of sham. You don't actually have to make a sound commercial decision. That is not the requirement or any obligation under the Act. But bear in mind that if there is a lack of rationale, or there's a patently flawed rationale to your commercial decision, that of course is what someone who is disgruntled by the decision will rely upon to suggest sham or pretext. And even if it is a rational decision, ideally your client or you need to be supported by contemporaneous evidence of the decision to restructure, because that is the way in which you draw away from the suggestion that the decision is personal, and this is just a pretext to get rid of a personal employee. Over to Dan.
So we come to pooling. It's one of those issues people often feel quite nervous about, but we're going to jump straight in. And before I go any further, the point that Lachlan has made about fairness is a good one. Pooling is simply an aspect of fairness, and there are no hard and fast rules. The case of Capita, which is on the slide, illustrates this point quite nicely, because the claimant was one of 4 actuaries, and yet when there was a loss of work, the respondent took the view that only the claimant should be put at risk of redundancy. It was argued that most of the work that had been lost was attributable to the claimant's funds or to the clients that she had. And the respondent argued at the tribunal that if one of the other actuaries had been made redundant, clients might have gone elsewhere if they had been reallocated to the other actuaries. That was what the respondent argued, but the tribunal didn't accept it. It found that the risk of that happening was only slight. And so, in short, the employer had not established any logical reason for only including the claimant in the pool, essentially a pool of 1 for redundancy, when there were others doing the same or similar work to her. And in Capita, the EAT confirmed that the decision of the EAT of the ET, that the redundancy was unfair, was one the tribunal was entitled to come to, and the EAT set down a number of principles. Again, it emphasised, first of all, the importance of section 98.4. I won't say any more about that, given what Lachlan has just said, but the other principles you may be familiar with when dealing with, for example, conduct dismissals apply here. The tribunal must not substitute its own view. The range of reasonable responses test applies. And in fact, there's no requirement that a pool includes only those employees doing the same or similar work. It's possible that a pool could include employees doing different jobs. The main point is that an employer has to consider who should be in and who should be out, and be able to give logical reasons for that decision. If an employer is not able to do so, he is at risk of the tribunal taking the view that he has not genuinely applied his mind to the issue. And that's what happened in Capita. There was no logical explanation on the tribunal's findings for the employer's decision to limit the pool to one. But if the employer has genuinely applied his mind to the question, Capita makes it clear that it will be difficult, albeit not impossible, but nevertheless difficult for an employee to challenge that decision. So that's the starting point. But if we move on to the next slide, we can see that in fact, there is no statutory or no firm requirement to have a pool. In the Wrexham case, the respondent decided that it no longer required the role of club steward, that the duties of club steward could be reallocated to other staff. And it didn't consider pooling at all. It just said the club steward was at risk of redundancy. And at first instance, that was found to be unfair on the basis that a pool was not considered. But the EAT didn't agree with that, and it held that there is no requirement in every case for there to be a pool. An employer may consider a single employee, and it referred to a pool of one being a somewhat inelegant phrase representing an underlying reality. So I hope what those two cases illustrate is that there are no hard and fast rules here. It's about having a clear rationale for the decision made. So if we go on to the next slide, please. So what are the key considerations then when an employer is deciding who to include or exclude from the pool? Lachlan's going to talk later about the issue of consultation, and consultation applies to all aspects of the redundancy process, and indeed it applies to the pool. Consulting your employees, consulting unions about who should be in and who should be out is a very wise idea. It may help you to make better business decisions, and certainly if the pool is going to be challenged, knowing what your employees think at an early stage is going to give you the opportunity to address those concerns before anyone is dismissed or any claims are issued. The second point is that generally good reasons will be needed to depart from established practice. Some might say, and it's certainly arguable, that COVID-19 might give rise to such good reasons to depart from previous policy or practice, but do not rely on that mantra. Do not simply say, we are in a new normal. Clear evidence will be needed, clear reasons ought to be provided, and again, it's something you should discuss with potentially affected employees. The other point has already been made in Capita, but those doing the same or similar work should generally be in the same pool. In the Thornley case, there were 7 specialist technicians. 5 of them worked on Maserati and Ferraris, and the others worked on Lotus cars. The employer restricted the redundancies to those in the Maserati workshop effectively, but it would only have taken 10 days for someone to have trained to work on Lotus cars. Essentially, the work was similar, all the same work. And again, there was no logical reason in the tribunal's view for restricting the pool in that way. And so essentially, the tribunal took the view that the employer had not genuinely applied its mind to who should be in the pool. It had no logical explanation. So that shows why it's important to consider which groups of employees do the same work or similar work. That's an important consideration. But on the other hand, the contract bottling case, I won't go into all of the facts, but in that case, the respondent included within the same pool people in sales, production, stock control, quality control, accounts, and warehousing, all in the same matrix, all to be judged according to the same criteria. The tribunal at first instance said that the people in the pool had a divergence of skills, or in some cases totally incomparable skills, and the consequence of the approach was that staff might need to be retrained. So a warehouse manager might need to be trained in accounts, or someone in quality control might be dismissed even though there was no shortage of work in that area. Now, contract bottling is not a model to follow. The dismissal was unfair for various other reasons, and the tribunal certainly expressed surprise about the pool that was identified and used in that case. But it was not a ground upon which the claim of unfair dismissal succeeded. So that shows that it's not necessary to have employees all doing precisely the same work in the same pool. You can have a broader pool. And if we move on from there, the Caverna Oil case is a case in which there were employees employed for historic reasons under essentially two separate management structures. They had their own budgets and management systems, and the respondent didn't consider all of those employees together. But the tribunal held that in essence the employees on the ground all worked at the same place, the work was interchangeable. They did not appreciate the differences within the business or corporate structure. And essentially it was therefore not reasonable to restrict the pool as the employer had done. And going back to section 98.4 and thinking about substantial merits, those sorts of formal and technical distinctions don't really strike a chord with that concept of substantial merits. So they're not irrelevant, you don't have to ignore them, but do be careful about over-reliance on formal technical management or organisational structures. And then the next point in relation to interchangeable jobs, that was a case where there were 3 drivers and 3 warehousemen, and the drivers could do the jobs of the warehousemen, but the warehousemen couldn't do the jobs of the drivers. The pool was restricted only to the drivers, and that was considered to be unfair because they had interchangeable skills. So that's again, there's no logical explanation for that. And finally, in relation to multi-site redundancies, an employer will have a broad discretion in deciding whether to limit a pool to a particular location or to include employees from all its sites or from any group of its sites. One thing that arises from COVID-19 is if people have been working from home, working remotely or working flexibly, thought should be given to defining a pool based on a particular office or site location, if in fact people have been working all over the place. It might be arguable that the employees should be grouped in some other way rather than by the notional office they were employed at the start of the year. And similarly, employees who move around, who travel, who work at different sites, some care needs to be given in terms of deciding whether they should be lumped into a particular pool or not, if in fact they're spending more of their time at a different site. So those are the key considerations on multi-site redundancies. If we go on to the next slide, we're over to Lachlan.
And as you can see on your screens, I hope that is consultation. And next slide, please, Liz. That is oh so important. It's this phase of the process that will define whether or not you've got a disgruntled employee wanting to challenge the decision or not. A quality consultation ensures reasonableness, fairness, and it's the right thing to do. And that's not least because it guards against the risk of an unfair dismissal. Now, we all know from Williams and Compare Maxim that consultation must be meaningful. Simply jumping through hoops will not do. And it won't do for two reasons. One is because it's susceptible to challenge for unfair dismissal. But the other is because actually, at the time that the consultation is taking place, it's pretty obvious to the employee that's what you're doing. And that gives rise to disgruntledness, which of course gives rise to challenge, whether or not that challenge is successful. The purpose of consultation is to give a voice to your employee. So that means they've got to be heard. Listening requires engagement with the issues, taking up the suggestions raised by the employee and dealing with them. This is all advice that I'd expect many of you who've signed up will be advising your clients in order to avoid complications further down the line. Yes, of course, your clients, the organization must comply with written procedure, absolutely. But don't be afraid to depart from written procedure if by doing so, you're actually increasing the fairness to the employee. For example, you could give additional meetings. The written procedure might anticipate a number of meetings, a set number of meetings, likely to be 3, not likely to be less than 3, but a set number of meetings. But you could add more. And the reason why you might want to have more is because you might need to address specifically issues raised by the employee. And they're unlikely to be found in any written procedure because they'll be personal to the employee. And the purpose of consultation is to provide them with a clear and a reasoned response in respect of the issues that they have raised. Don't be afraid of that. This slide says don't be afraid. Next slide, please, Liz. Don't be a robot either. So the decision maker should not be reading from a pre-prepared script. Totally understand in large organizations, the reliance upon human resources, the reliance upon guidance from human resources is such that decision makers feel out of their depth. But first and foremost, it is not too much to expect a thorough appreciation by the decision maker of all the issues that are ultimately risking the removal of somebody's livelihood. So decision makers, this may sound flippant, but so often it is the case that decision makers appear too busy and so therefore read from a script. And if they are so ill-disposed to engage meaningfully in the conversation that they are having, in the discussion that they are having with the employee, they're not appropriate to be decision makers. Decision makers need to provide an element of dignity, courtesy, and respect in the whole process if they are going to get what I said at the very first slide in this webinar, if they're going to get both sides looking at it from the same viewpoint. Nobody expects a job to light, or very few people expect a job for life. A lot of people in these current circumstances will understand why a business is facing trouble. It doesn't take much to at least endeavor to persuade the employee to understand precisely why the organization has difficulties and the decisions that they are taking reluctantly to let go of employees. Don't take my word from it. We've got a couple of authorities here now that talk about what is required in consultation. Proposals at a formative stage, not after the decision has been made. Consultation needs to discuss proposals at a formative stage. Consultation needs to provide adequate information on which the employee can respond. And it needs to give the employee adequate time to respond. And there should be conscientious consideration in response to the consultation. It doesn't take much to personalize a consultation process beyond what is written in the written procedure. Next slide, please. And if you get it wrong, here's a good authority for how you might get it wrong. Thomas and BNP Paribas. A perfunctory consultation with a lack of sensitivity is likely to render the dismissal unfair. And the example in that case came about where they put a long-serving employee on gardening leave with no work, no contact with fellow employees, and no contact with clients, even before the consultation process has started. So at the supposedly formative stage of consultation. Now that, of course, will instantly give rise to a feeling in the employee that it's a predetermined decision, which instantly gives rise to a meaninglessness felt about the consultation process at all. Of course, organisations need to protect their sensitive information and may feel that just the mere whiff of redundancy may make disgruntled employees risk their sensitive organisation. But there are other ways of dealing with that. IT is very intelligent now. IT can control sensitive information and leaking of it without necessarily the employer showing a breach in trust at that early stage of what should be a transparent and open consultation process. So, leaving this subject of consultation, Dan's already mentioned it, consultation can inform the whole process. You can consider at an early stage whether you need consultation to actually inform you about, for example, the scope of the pool. Who should be in it? You could use consultation to inform you about that. Be careful. It would be invidious to ask employees to bring fellow employees into at risk of redundancy. So that needs to be approached with caution. But you can inform fellow employees and can consult with them about the scope of the pool and about the scope of the criteria to be used for selection for redundancy. Consultation can inform the whole process. Now over to Dan.
Let's get started with selection. So most of you will be familiar with the seminal case of Williams. It's been mentioned by Lachlan, and it really sets out quite nicely in this quote what selection is all about. Again, discussing or consulting about the selection criteria is important, and the words in Williams are that the criteria should, as far as possible, not depend solely upon the opinion of the person making the selection, but refer to objective matters such as attendance, efficiency at the job, experience or length of service. And the point I highlight is that even in Williams, the very seminal case, it doesn't say all criteria has to be 100% objective. It says it must not depend solely upon the opinion of the person making the selection. And it's important to bear that in mind. On the next slide, we see a similar quote. I'm not going to go into the details of that case, which was very complex in terms of its facts. But the point made by the EAT was that our law recognises that in the real world, employers making tough decisions need sometimes to deploy criteria which call for the application of personal judgment and a degree of subjectivity. It is well settled law that an employment tribunal reviewing such criteria does not go wrong so long as it recognises that fact in its determination of fairness. So it's important that this is very clear. An element of personal judgment or even a degree of subjectivity is not of itself going to render a dismissal unfair. In fact, the opposite can be true. A purely objective process with little input from those who know the employees can cause problems, and we see that on the next slide. So in this case, the respondent operated a residential hospital, and it decided to close one of its wards, but rather than focusing the pool on the nurses and support staff in that particular ward, it drew the pool much more widely and considered nurses and support staff across the whole hospital. It devised a procedure which involved the following. There was to be a competency assessment, which was to include both a written assessment, an interview with preset questions, and also a group scenario where there would be a discussion of a hypothetical situation. In addition to those competency assessments, disciplinary records were to be considered, and so was sickness absence. Those were methods used by the respondent in recruitment. They were methods and tools used by HR, and HR were very familiar with them. There was a consultation period of 30 days. There was a right of appeal built into the process. Staff were told that there would be vacant or told of vacancies in the region. There were several meetings, and the written assessments were moderated to ensure uniformity of approach. But none of the individuals conducting those assessments had worked with the employees at risk of redundancy. And the respondent accepted, or was forced to accept in the tribunal, that this process created some very strange results. Some individuals who had been considered to be very good employees were selected for redundancy. Nevertheless, the respondent took the view that this was an objective, robust process and followed through in dismissing those very good employees. The tribunal, despite all of the efforts on the part of the employer to ensure objectivity and make sure there was no element of bias, held that the dismissal was grossly unfair. This was not a recruitment exercise. The opinion of those who knew the work of the employees was completely excluded. And as the EAT recognised in the quote shown on the slide, this was an elaborate and HR-driven method which deprived it of the benefit of input from managers and others who knew the staff in question. The goal of avoiding subjectivity and bias is of course desirable, but it can come at too high a price. And if the fear is that employment tribunals will find a procedure unfair only because there is an element of subjectivity involved, that fear is misplaced. So the point is, yes, make sure your selection criteria are objective, but plainly you need to take account of the skills of your employees. You need to consider the opinion of their managers. You need to look at appraisal documents rather than making everything divorced from what you know of the employees and focusing solely on purely objective assessments. And that's this slide. If we move on to the next one, please. Other selection criteria. There are no fixed criteria. Historically, last in, first out was used, but that's going to be indirect age discrimination these days. Common criteria that have been referred to in the case law include the length of service, performance, skills and knowledge, flexibility, attendance, and disciplinary records. There is no fixed list. Bear in mind that some of these criteria do potentially pose risks in terms of discrimination, and I'll come on to talk about that in a little while. But that's all I propose to say. Keep an open mind, think about what works for your client or for your business. In terms of the application of the selection criteria, it's very clear the tribunal, as I've said before, is not there to substitute its own view. It's not entitled to embark on a reassessment exercise. That's been made very clear. And even where the application of the selection criteria might involve a potential for subjectivity, for example, where one is conducting interviews, that can be mitigated by checks and balances, such as those referred to in the Canning's case, which included where you're having an interview, making sure that the people on the panel are appropriate in terms of their training, their experience, their seniority, making sure that you have more than one person scoring an individual, making sure each member of the panel separately scores the individual and then their results are moderated or brought together. And if you do that, if you make sure you put in as many checks and balances as you can, again, the argument that there's some level of subjectivity is not going to render the dismissal unfair. So that's all I wish to say about this slide. And then that brings us to COVID-19 and the context of that. Again, think about the assessment period you're looking at. If you're looking at performance or sickness absence, people have been working in very unusual ways. In very challenging times, people have had to shield or self-isolate, or might be living with people who've had to shield or self-isolate. You're going to have to give some thought as to what assessment period to use. If one was to assess employees purely over their performance during the lockdown, I can see that there might be some problems with that and issues raised in the tribunal. So that's a factor to consider. Also consider the potentially automatically unfair reasons. Section 100 of the Employment Rights Act effectively enables employees to stay at home in circumstances of danger. It's possible some employees might seek to rely on that. Or there might be protected disclosure cases, perhaps related to whether social distancing is in place or whether all other safety measures are being taken. If you end up selecting an employee who perhaps has raised those concerns, you may be at risk of finding that the dismissal was automatically unfair. So be careful about that. And again, if you're taking into account absence, bear in mind the reasons for that absence. Health and safety or health issues related to COVID-19 need to be considered. And as I said before, think about discrimination, age, disability, sex, and maternity and pregnancy are going to be relevant. Sex in terms of women typically having childcare and or other caring responsibilities, age and disability in terms of people shielding. Also think about associative disability if people are living with disabled individuals. One needs to be careful about adopting criteria that might indirectly discriminate against those people. Also, I note that selecting someone for redundancy on the grounds of pregnancy or having taken maternity leave will be regarded as automatically unfair under the maternity and parental leave, etc. regulations. Over to Lachlan.
Okay, we're now dealing with the question of alternative employment. First slide up, please, Liz. Obviously, it needs to be covered, and it needs to be covered very carefully, but my first sounding point, my first warning is don't do it too soon in the consultation process, because your initial consultation process is to give warning of at risk of redundancy, not that the role is redundant. And so embarking upon an exploration of alternatives at the outset from an employer's perspective may appear to the employee as the decision of the role being redundant predetermined. Ensure there's a system in place, bringing alternative vacancies to the employee's attention, and bear in mind the alternative vacancies may be in group companies as well. And it may be deemed to be unfair if you have not looked further afield for the possibility of alternatives. And bear in mind any notice period served, particularly if the employee is on garden leave, that may enable the employee to access any outplacement services that you may have provided. In that period, any opportunities arising during that time are capable of constituting alternative employment. And if obviously there's more than one potentially redundant employee, you've got to ensure that all are made aware of any vacancies, else you risk some kind of discrimination claim. Ensure that. Next slide, please, Liz. What is the duty? Well, the duty is not actually to offer an alternative job. The obligation is to make reasonable efforts to find potential alternative roles for the employee and for them to consider or apply for. Avoid assumptions about roles. Failing to raise some vacancies due to assumptions of unsuitability can lend support to an unfairness challenge. And do bear in mind the availability of training to make actually an employee suitable, and the ease with which training may make an employee who might otherwise be unsuitable, suitable for a particular available role. Be aware of any internal redundancy redeployment procedures. Once again, I go back to always have regard to your written procedures. Don't worry about offering beyond them if they are advantageous to the employee, but always have regard to your written redeployment procedures. Ensure the business continues to search for possible employment up until the dismissal takes effect. What have you got to consider? You've got to provide sufficient information about the vacancies so that they can make an informed decision. So that might include the financial prospects of the vacant alternative positions, even if the finances are less. I have noticed amongst the questions that we will try and provide an answer to, there's a question about possibility of having salaries ring-fenced. That may very well be the case. In fact, you may have a salary ring-fenced as a result of either through collective bargaining or through the contractual position. That's something to bear in mind. Potentially redundant employees on maternity or adoption leave must be offered suitable alternative vacancies first. For any other vacancies, the business is entitled to undertake a competitive interview process and appoint the candidate considered best for the job. And that's what Dan has touched upon in the alternative, if you like, for selection for redundancy, is selection for a new role. Overriding both of them is obviously the duty to act fairly. Next slide, please, Liz. And of course, in all of the provisions of alternative, throughout the entire process, the risk of discrimination needs to be considered and obviously avoided. So that's when considering whether there are any suitable vacancies and in the process for deciding which potentially redundant employees should be offered a vacancy. One final aspect that I've not produced or reproduced on the slides in the current climate is the extent to which the ability to go back on furlough, be placed on furlough, remain on furlough, actually comprises a suitable alternative or an alternative to redundancy, which, if not offered, might give rise to a claim of unfairness. Now, let me be absolutely clear. An employer has been entitled to make redundancies, even throughout the coronavirus job retention scheme's period of operation. So I would not for 1 minute suggest that making an employer redundant during that period and not availing themselves of the coronavirus job retention scheme would give rise to a successful challenge for unfair dismissal. But it might. It would depend on the circumstances of the case. But if it is the case that an employer who says the future is uncertain and for whom the future could be anything in the next 1 or 2 months, who at the early stage of the coronavirus job retention scheme pulled someone off it and made them unemployed, taking advantage of the notice pay also being provided under the coronavirus job retention scheme, there are potential arguments there for suggesting that it was unfair not to retain on the coronavirus job retention scheme. Not a surefire argument, something that would need to be tested, but it is there and something for us to be mindful of, particularly when we're advising employers who have made redundancies during and certainly in the early stages of the operation of the coronavirus job retention scheme. Ultimately, of course, it will always turn on its own facts.
Procedure. Thanks, Lachlan. We can go on to the next slide. Before I get into it, I'm just going to pick up on a few questions that I've seen in the Q&A chat box. The first one was, is there a statutory definition of pooling? The answer is no. As was made clear in Capita, it's section 98(4). And it's not necessary in every case to have a pool at all. So there isn't a specific definition. It is a matter for the employer to decide how to define the pool. In relation to appeals, we'll come on to discussing appeals shortly in my discussion of procedure. There's a question about psychometric testing, whether that could be a fair process of scoring in a redundancy selection. Never say never. It might depend on the particular job. If you've come up with a new job role that's substantially different from the previous one, it could have a role. But I would be extremely wary of it for the reasons referred to in the previous case. It seems divorced from how somebody has actually been performing. And if you've got an employee who's been employed for a significant period of time with good appraisals and generally considered to be a good employee, making them redundant based on a psychometric test, I think would be very dangerous indeed. Last in, first out criteria. Again, I think it's dangerous these days. It's likely to be indirect age discrimination. Of course, that can potentially be justified, but I think you would have to think very clearly about your reasons for that. And I'm going to come on to now to discuss the competitive application process and Morgan and the Welsh Rugby Union, which deals with a very different type of situation to Williams. It deals with a situation where employees are going through interviews rather than being judged according to a scoring matrix. And in Morgan, it was accepted that Williams doesn't really seek to address the situation where there's been some form of reorganisation, and in fact there are new roles to be created going forwards. That being so, Morgan makes it clear that the approach will always have to be forward-looking if a new role is being created, and the focus will be on the employee's ability to perform in the new role. It's going to be particularly appropriate where one is recruiting at a high level, or where an employee is being promoted to a higher level than previously. There they will need to prove competence beyond that perhaps they had in their previous role. So that was the general guidance provided in Morgan, which is a very well-known case. But beware, it's often been said, or often people take the view that a certain type of redundancy is a Morgan redundancy or a Williams redundancy, an interview or a scoring matrix, and that completely different principles apply. Recent case law has shown that there isn't such a binary distinction between them in terms of what will be expected in relation to fairness. And in the case of Green, that's shown on the slide there, the claimant had been through an interview process and she complained about the fairness of that process. The EAT held that the tribunal had to decide not as whether the redundancy was unfair, but in terms of why she had not been selected for a new role. And the tribunal held that the EAT held that the tribunal had been blinkered by Morgan. It saw it as a quick fix, as a solution, as if it were a hard rule of law, when it's not a hard rule of law at all. The test is always section 98(4), fairness in the particular circumstances, taking into account the merits of the case. So one has to bear in mind that there isn't a rigid distinction between the matters which go to fairness in Williams situations and those which apply in Morgan. And very recently, the 3rd of June this year, the judgment of the EAT in Gwynedd Council was handed down, and that illustrates the point, in my view, quite nicely. The facts, again, are a little complicated, but as follows, as a summary. The claimants were teachers employed in what was called School 1. Their employer was the local authority, and the local authority decided to reorganise schools within its area, and the claimants were required to apply through interview for a job at School 2. They were unsuccessful in their interview, and they were told they would be made redundant. There was no opportunity to appeal, and when they raised that with the employer, they were told it would make no difference. They of course claimed unfair dismissal. The tribunal at first instance addressed the respondent's argument that the lack of an appeal caused no disadvantage. It said that that was extraordinary, ill-conceived, and emphatically wrong. It found the dismissal to be both procedurally and substantively unfair, noting that an appeal is ingrained as one of the matters in terms of natural justice. Of course, it doesn't in every case. The absence of an appeal won't in every case render a dismissal unfair, but the point was made, you can't simply say this is a Morgan type situation and therefore as a matter of law, no appeal is needed. And on appeal to the EAT, the decision of the tribunal was upheld. The president thought that this was a case where the employees had no opportunity at all to grieve or be consulted about their dismissals, and it was wrong to simply regard the fact that they were going to be interviewed for a new job as meaning that consultation was irrelevant, effectively requiring someone to apply for their own job. Essentially, they were still going to be teachers, just at a different school, or for a very similar job, is not an appropriate way of dealing with the issue of alternative employment of itself. Certainly not in the facts of Gwynedd Council. And so that case shows that you can't just simply ignore the issues of consultation, of appeals, and of alternative employment if you're following the more Morgan type pathway of requiring interviews rather than using a scoring matrix. So of course interviews can be used, but think about whether it's appropriate. Are you asking employees to undertake a different job, or is the job going to be exactly the same? And if it is going to be more of the same, make sure you really do think carefully about appeals, about consultation and so forth. We all know Polke. It was a redundancy case, and it does make it clear that the procedure that's usually expected is as follows. An employer will normally not act reasonably unless he warns and consults any employees affected or their representatives, adopts a fair basis for selecting them, takes such steps as may be reasonable to avoid or minimise the redundancies by redeployment within the organisation. Those are all things we've touched on already. And so that's the general point. There is no relevant ACAS code. Someone asked, does an appeal look exactly like it would in terms of a misconduct appeal? Well, of course, it's going to be different. You have to address the issues the employee is raising. Are they challenging their scoring? Are they suggesting the selection criteria was wrong? You need to consider and engage with those issues. Lachlan's already mentioned the case of Thomas and how perfunctory consultation to be a strong indicator that a dismissal was procedurally unfair. Again, follow existing policies unless there are good grounds for departing from them. If you're going to rely on COVID-19, don't just do so in a broad brush way. Make sure you're very clear and specific about why the pandemic justifies such a departure. And as I said, appeals, consider whether you should have an appeal. Not only is it useful in terms of fair procedure, there's also a second reason it's relevant, and you may be familiar with the case of Taylor and OCS, and that's not a case involving redundancy, but it makes it plain that when assessing fairness, the tribunal is looking at matters in the round, looking at the procedure as a whole. And if mistakes have been made at an early stage, and gives an employer an opportunity to correct any errors and therefore avoid a potential finding of unfair dismissal. So those are the points relevant to procedure. As I say, there's no prescriptive rules. The final point is dismissing without any procedure at all. It's definitely not a good idea. Nothing I say should be taken as encouraging or advising it. But there is a little bit of hope. If a client comes to you and says, I've dismissed all of these employees, there is just a sliver of a chance, and in certain circumstances, in rare and exceptional cases. And it's this. In Polke itself, it was said that although procedure is expected, if the tribunal finds that the employer at the time of dismissal acted reasonably in taking the view in the exceptional circumstances of the particular case, that the procedural steps normally appropriate would have been futile, could not have altered the decision to dismiss, and could therefore be dispensed with. Essentially, the dismissal may nevertheless be fair. But the test is one of, was a procedure futile? It's a high test to meet, and I don't advise trying to argue it unless you really feel the evidence is so strong, or if you've really got no alternative. But don't forget it's an important point to put in pleadings in an appropriate case. So I hope that's a whistle-stop tour through procedural fairness. I think that brings me to an end of my section.
Brilliant. Thank you, Dan. Okay, we're going to just try in the last few minutes that we've got left remaining of the webinar just to answer a few questions. I'll start answering a couple of questions that deal with consultation, and that'll give Dan an opportunity to perhaps read some of the questions about selection. A question from Michelle, which is actually in the webinar chat and hasn't managed to find itself in the question and answer, but I did want to answer it. Do you consider it necessary to consult regarding pooling and selection criteria if there are less than 20 proposed redundancies? The simple answer to that, Michelle, is no. No, it's not necessary to consult. And you're saying specifically with regard to that small workforce, but it's not necessary to consult regarding pooling and selection criteria at all. But I go back to the original tenor, and I'll be doing that in the questions that I answer as well, of my slides and my talk that really focused on transparency and keeping the employee engaged in the process so that they feel they have been treated fairly. So sometimes it might be prudent to consult about pooling and the selection criteria in order to convey that feeling of having the employee participate in the process. Because ultimately, if you do that, you don't get a disgruntled employee wanting to challenge at a future date. A question from Edward Ween. Hello, Edward. Nice to hear from you. Is it necessary to consult with employees in the pool who have not been selected by reference to the matrix scores? To consult with such employees might be to unnecessarily worry them. Equally, not consulting with them gives the appearance of prejudgment of the outcome of the consultation process. And this is similar to my answer to Michelle, Ed. It's very much this. No, it's not necessary to do that. And certainly if you have embarked upon a matrix prior to consultation, then of course you would really need to consult as a matter of urgency those that are at risk of redundancy because of where they featured in the matrix. But I also go back to my caveat that I gave to Michelle, and it's this. What are you trying to achieve in terms of transparency and criteria? If those who are consulted say, well, hang on, what is the pool? Who are you comparing me with? Are you going to keep it from them or not? If you're not going to keep it from you, if you can define the pool in generic terms, all the administrative staff, all the staff at clerical grade, whatever, if you define it in that case, then it will look very bogus if some of the people in that category have not been consulted with. It would suggest there isn't such a pool has been undertaken, and it would suggest personalisation of decision. So it's not necessary, but it may be prudent to do so to give transparency and the appearance of equality across the board. I hope that helps. Dan, if you've got any questions you'd like to give answers to, please do say so, but I'm very conscious that we are right at the end of our time slot. But Dan, over to you if you would like to.
Thanks, Lachlan. Just one or two. I think someone's asked, in light of my comments about last in, first out, well, isn't there a similarity between last in, first out and length of service? Well, yes, there is a similarity, but last in, first out being used as a sole criterion, I say is very clearly likely to be indirect age discrimination. There's a difference if you're using length of service as one of many potential criterion within a matrix, although you might have to give some thought to how much weight you give to length of service. Plainly, if it was given a huge amount of weight, that argument could still be made depending on the age of the workforce you're dealing with. And so I think that answers that question. I'm just looking to see if there are any others I can quickly answer other than in light of the time.
While you're looking, Dan, can I just quickly come back to Chris on the suggestion of not offering alternative roles too soon? That was my suggestion. And the question is, can an employer consult on the basis that their proposed structure is a fait accompli but perhaps the exact outcome of that restructure can be consulted on. I hope this isn't an unsatisfactory answer, Chris, but the answer is yes, possibly. And it depends very much on the circumstances as to where there is unfairness. But yes, an employer could determine that they need a restructure in order to achieve a certain amount of either financial savings or a certain amount of efficiency to their client base. And they can say, we are definitely going to do that, and then ultimately consult on alternatives within the structure. Yes, it is possible. Nothing is certain until the facts are seen, but I re-emphasize the importance of keeping it very transparent and very fair for the individuals concerned, so that they know that they have been meaningfully engaged in the process.
And finally, for me, there are lots of interesting questions which would take me too long to answer. There's a question about whether bumping is permitted. Bumping can be permitted in certain circumstances, and I don't have time to go through that in detail now. But what I would say is go and have a look at the contract bottling case mentioned in my slides. And I think that gives some useful discussion on bumping.
Finally, because what I'll do is I'll draw this now to a close, but I do want to ask the question, does us leaving Europe change anything? The simple answer to that is no, not at this stage. Watch this space. Might there be new legislation introduced with the Supreme Westminster government in power? Possibly. But at this stage, leaving Europe changes nothing. I do hope you found this helpful, meaningful, and of assistance to you in your respective roles that you all have. And what I will do now is I will draw this webinar now to a close, and thank you all very much indeed for attending, and thank you particularly for your questions, because it's questions such as that you ask that, as I've already hinted on, frame what we address in future webinars and how we actually provide a meaningful service to you. Thank you very much indeed all for attending.